Before any piece of non-testifying evidence, such as a document, photograph, or recording, can be admitted into evidence, it must first satisfy the requirement of authentication under Federal Rule of Evidence 901. Authentication is the foundational prerequisite that demands the proponent produce sufficient evidence to support a finding that the item is what the proponent claims it is. This is not about credibility or weight. It is about identity. If you claim this letter is from the defendant, you must prove it is, in fact, that letter. This requirement stands distinct from the broader concepts of relevance, governed by Rules 401 and 402, which deal with whether the evidence tends to make a fact more or less probable. Authentication acts as the critical gatekeeper. It must be satisfied first. Only after the judge confirms the item is what it purports to be, only after the gate is opened, do we proceed to analyze subsequent issues like whether the evidence constitutes hearsay or if any privilege applies. Think of Federal Rule of Evidence 901 as the mandatory entry ticket for all physical and electronic exhibits. Now that the gate is open, we must address the precise standard the proponent must meet to satisfy authentication under Federal Rule of Evidence 901. This standard is governed by Federal Rule of Evidence 104(b), which deals with conditional relevancy. The proponent must produce enough evidence to support a finding that the item is, in fact, what the proponent claims it is. Crucially, this is a very low threshold. The judge is not deciding whether the evidence is actually authentic. Instead, the judge only determines if there is sufficient evidence such that a reasonable juror could conclude the item is genuine. If that minimum threshold is met, the evidence is admitted. The ultimate decision regarding the credibility and the weight to assign that evidence is then reserved entirely for the jury to decide during deliberation. Think of this as clearing a low hurdle labeled sufficiency threshold. We have established that the proponent only needs to clear that low sufficiency threshold. Now, how is that threshold typically met? The most common and direct method of authentication is through the testimony of a witness possessing personal knowledge, as codified in Federal Rule of Evidence 901, subsection B, Part 1. This witness must testify based on what they personally observed. This means they must have seen the item created, they must have handled the item themselves, or they must recognize the item based on prior familiarity with it. For instance, consider a witness taking the stand and testifying, "Yes, I saw the defendant sign that document. That is absolutely his signature." Alternatively, imagine a police officer testifying, "I personally inventoried this specific firearm at the crime scene, and I recognize it now based on the unique markings I recorded." This direct, first-hand connection between the witness and the item provides the necessary foundation to satisfy the rule, moving us from the general standard to the most frequent practical application. Moving beyond direct identification by a witness who saw the item created, authentication can also be achieved through comparison, governed by Federal Rule of Evidence 901, subsection B, Part 3. This method requires comparing the disputed item against a specimen already established as genuine. The key distinction here lies in who is performing the comparison. If the comparison is conducted by an expert witness, they utilize specialized knowledge, such as handwriting analysis or forensic science, to verify similarity between the unknown item and the known exemplar. Conversely, if a lay witness performs the comparison, they must first establish familiarity with the genuine item outside of the litigation context. For example, a witness might testify they recognize the disputed signature because they have seen the purported signer's genuine signature hundreds of times in their capacity as a bank teller, before this lawsuit ever arose. The foundation here rests on the reliability of the comparison itself, whether guided by expertise or by prior, non-litigation familiarity. We have covered identification by a witness and authentication by comparison. Now, let us examine the third pathway under subsection B, Part 4, authentication based on distinctive characteristics. This is often termed circumstantial authentication. This method becomes crucial when direct identification or comparison against a known standard is impractical or impossible. Federal Rule of Evidence 901, subsection B, Part 4, allows authentication if the item possesses unique features inherently suggesting its genuineness. Consider the item's appearance, its content, its substance, or specific internal patterns. For example, a contract might contain proprietary jargon known only to the parties involved, or a letter might display a specific, hard-to-replicate watermark. These intrinsic qualities act as silent witnesses to authenticity. If the evidence's own characteristics point strongly toward its claimed origin, the foundation for admission is met, relying entirely on the inherent nature of the exhibit itself, without needing external testimony about its creation. Moving beyond static documents, we now address the authentication of dynamic evidence, audio, video, and electronic recordings. These present unique challenges because they are easily manipulated. The foundation here typically requires testimony confirming that the recording accurately depicts the events or conversations as they actually occurred. This testimony often comes from a participant in the event, who can vouch for the content, or from a technical expert. The expert must establish the integrity of the recording process itself, confirming the equipment was functioning properly and that there has been no material alteration to the file or tape. In our modern digital landscape, courts apply heightened scrutiny to this type of evidence. Proving the chain of custody and ensuring the digital file has not been tampered with is paramount to satisfying the foundation requirement for electronic media. While laying foundation through testimony or comparison is the general rule, the federal rules of evidence recognize certain documents are so inherently reliable that they authenticate themselves. This brings us to Federal Rule of Evidence 902, covering self-authenticating documents. These documents bypass the need for any extrinsic evidence of foundation because the law grants them an inherent, conclusive presumption of genuineness. The most frequently tested examples involve official documentation. First, certified copies of public records, such as court judgments or vital statistics, accompanied by a certificate from the custodian. Second, documents bearing an official seal and signature, like documents from foreign governments or certain federal agencies. Third, acknowledged documents, meaning those properly notarized, which carry the presumption of genuineness based on the notary's certification. Finally, certain commercial paper, like negotiable instruments or bank documents, are also self-authenticating. Mastering these exceptions saves significant time in trial preparation. We just covered documents that authenticate themselves. Now, let us turn our attention to one of the most frequently encountered documents in litigation: business records, governed by the hearsay exception found in Federal Rule of Evidence 800. 3. Subsection 6. Crucially, even if a record qualifies as a business record, it still must satisfy the general authentication requirement under Rule 901. This means you must prove the document is what you claim it is. The foundation for admitting a business record requires testimony, usually from a custodian or another qualified witness, who can speak to the system of record keeping. This witness must confirm 4 key elements. First, the record must have been made at or near the time of the event by someone with knowledge. Second, it must have been kept in the course of a regularly conducted business activity. Third, making that record must have been a regular practice of that business. And finally, The witness must be able to attest to the trustworthiness of that entire process. Remember, the focus here is on the reliability of the system, not just the content of the single document. We have just reviewed the necessary steps to affirmatively lay the foundation for complex evidence like business records. But what happens when the opposing counsel fails to meet that threshold? This is where your role as a litigator becomes crucial. If you believe the proponent has not provided sufficient evidence to support a finding of authenticity, or to satisfy the requirements of a hearsay exception, you must object immediately. The specific, required objection is, objection, lack of foundation. When this objection is raised, the judge steps into the role of the preliminary fact finder under Federal Rule of Evidence 104, subsection A. The judge must decide, outside the presence of the jury if necessary, whether the proponent has met the minimum threshold required by the rules. This is a low bar, merely enough evidence for a reasonable juror to believe the item is what it purports to be. If the judge overrules the objection, the evidence comes in, and the jury then takes over, assessing the ultimate weight and credibility of that evidence. Having seen how to challenge insufficient foundation, let us now synthesize this entire critical area. Remember this overarching principle: authentication under Rule 901 is the mandatory, non-negotiable first hurdle for every piece of non-testifying evidence seeking admission. Before relevance, before hearsay, the proponent must prove the item is what it claims to be. We explored 4 primary pathways to clear this hurdle: direct witness identification, authentication by comparison against a known exemplar, relying on distinctive characteristics through circumstantial evidence, and utilizing the shortcuts provided by self-authenticating documents. Mastering the tactical ability to either lay this foundation effectively or to challenge its absence decisively is not just procedural knowledge. It is a high-yield skill that directly correlates with success on the evidence section of the Uniform Bar Examination. Focus your study here.